Good afternoon. We are so excited to present our first webinar of 2022. And believe it or not, we're almost through this entire first month. I don't know how that happened. We hope that you and yours are staying healthy during this crazy month of January. Little note here for you all. If you're using the Internet Explorer as your browser to register for GoToWebinar, or for any of our webinars through GoToWebinar, the platform is not supported, or the browser is not supported. I apologize. If you're using Internet Explorer to try to register for our webinars, you cannot do it through Internet Explorer. You'll have to use Chrome or another supported browser. If you have any questions about that, please email me and I can send you some links. A couple of our very famous trainers, Zane Uriberry and Timothy Musak, are leading today's discussion with a shot of COVID and cola. I think this means you're getting 2 shots today. I'm not sure. I guess we're going to find out. Certificates for 1 hour of CE credits will be sent out later this afternoon. We are recording today's presentation, and you can find a copy of today's PowerPoint presentation on our website under training, or you can find it attached to your GoToWebinar panel under handouts. If you need additional CE credits, if you need a PD rating, updated workers' comp news via the B&B blog, please do visit our website at bradfordbarthel.com. It has all of the value-added services and more right at your fingertips. If you have questions, comments, compliments about our hair, please submit them in the questions section of your GoToWebinar panel. I know Zane and Tim like compliments about their hair. And with that, we're going to jump right into introductions. Natalie, you want to start us off?
Hi, everyone. My name is Natalie Hong. I am the Assistant Managing Partner of our Los Angeles office. I'm also one of the COVID panel attorneys who help do COVID claims as well as regular claims. In my spare time, I'm a mother of 2, and I also have 3 cats.
Sorry, I didn't want you to hear my typing. Anyway, good afternoon, everybody. I'm out of the Woodland Hills office. My name is John Kamen, and I'm a partner there, and I'm also the director of the firm's editorial department, which is a fancy way of saying that I run the firm's blog with the help of our wonderful team. And our blog is pretty good if you're a fan of Curb Your Enthusiasm with Larry David. And if you're not, you have no idea what I'm talking about. So don't worry about that. Now, before I became an attorney, I was a journalist, and I was at WorkComp Central for a long time. And where I'm going with that is if you forget any details of today's presentation, we already have Tim's blog on the website about the 2022 COLA stuff. And then we also have plenty of COVID content on the website as well. And with that, let me kick it over to Zane.
Good afternoon, everyone. I'm Zane Uriberry. I am from the Ontario office, a partner here, and I'll be going over the COVID section of the presentation today, following up a little bit about kind of what's happened with the COVID cases, what our experiences have been, but also what kind of questions do we usually get? We take a lot of questions at covid@bradfordbarthel.com, and we've looked at a lot of them have had similar themes, so we wanted to kind of address that and where these claims are going now. So we'll get to that in the second half of the presentation, but first I'm going to turn it over to Tim.
Hi, I'm Tim Musak. I'm with Bradford Barthel in the Sacramento office, and I do ratings is what I do. I'm going to talk about COLA today. I hope I'm showing my email address. I have about an hour and a half worth of material, but I understand that COVID is going to be a very popular topic. So I'm not going to give you an hour and a half's worth. So if you have questions, by all means, feel free to send me email questions regarding the topic, or give me a call, whatever works for you. Be glad to answer any questions. And this is me, and this is what we're going to talk about. So I think we're going to start with a couple of questions. Are we ready to get started, Tammy?
We are.
Thank
Our
you.
first poll questions should already be up on your screen, and Tim wants to know, what benefits can COLA affect? I'm going to close it in about 3 seconds.
Okay.
And I'm going to share those results on the screen now.
Very good. We had 80% said all of the above, and that's correct. Important. What this is really telling me is what kind of experience you have, not whether you know everything about the job, but what kind of experience you have. So thank you for responding, and I think we've got one more. Hopefully you respond to that one as well.
You should see that on your screen now. How many commutations have you reviewed in the last 6 months? Somebody wants to know, what does COLA stand for, Tim? Can you answer that while we're waiting here?
I can. It's cost of living adjustment. And about half have actually worked with commutations in the last 6 months. So thank you for responding to that. That helps me. We're going to talk a little bit about commutations and what COLA might have to do with that. So I'm going to get going here, but first, I'm going to show you, since I'm in the rating department, I'm going to show you on our rating website, we have Bradford Barthel 2005 rating schedule. It's no different from anybody else's or the DEUs, the DIRs, but we have one on our website that is really easy to use. You can click through the different sections and work your way through on ratings. It's downloadable. It's on our website. What we also have now on our website that you can get to is money charts. We've got all the current money charts information on this. This is also on our website. You get the current U.S. life table that we're using for 2022, which is the 2018 U.S. life table. We've got life pension rates, PD rates, TTD rates, everything in there. So those are on our website, and feel free to use those, download them, whatever. I use those often. They're really helpful, really easy to use, particularly if you can't get a hard copy or it doesn't fit on your desk when you're working at home. Sometimes things don't. So we're going to talk about COLA, and I'm going to try to go a little bit quickly through this because I want to hear more about COVID. State average weekly wage and cost of living adjustments. Back in 2003, California decided for workers' comp that we need to make adjustments to lifetime benefit claims. And the way we'll do it is we'll apply COLA. We're not doing this, we don't do Social Security COLA. We have our own COLA for California, and it's taken from the Department of Labor, gives us statistics about change in state average weekly wage. And it compares the first quarter of one year to the first quarter of the prior year, and the change, the percentage of the change becomes our COLA. That COLA affects our current TTD rates, our new TTD rates. This past year, we had a phenomenal state average weekly wage increase, according to the Department of Labor data, a 13.5213% increase. That's just huge. That's 2.5 times more than anything we've ever had before in California. So what that did was that greatly increased TD rates for 1/1/2022. So here's what COLA does. That's the effects of COLA. It affects directly TTD. So for 2022 dates of injury, we have new maximum and minimum rates. Temporary disability rates are based on 2/3 of average weekly earnings, subject to the maximums on the year of the date of injury. A big increase for this year. So TTD is impacted directly. Death benefits can be affected indirectly because they're to be paid in the same manner as TTD. So because of that, it can affect death benefits. It's not directly applied. It also directly applies to lifetime benefits, and lifetime benefits are paid on permanent disability of 70% or more for a date of injury. After that underlying permanent partial disability is paid, the injured worker is entitled to a lifetime benefit that increases depending on the amount of permanent disability. 70% or more, they're getting something, and it increases. Per total, if it's 100%, it's a different rate schedule there. Let's see if I can get myself clicked back in here so I can move forward. There we go. With TTD, and indirectly for death benefits, the 2-year rule applies. And the 2-year rule, the Labor Code 4661.5, I hope is right. I've got it later, and I'll correct myself if I'm wrong. TTD benefits paid 2 years after the date of injury are subject to the maximum and minimum earnings at the time of payment. Those are still based on earnings at time of injury. But if the person was a max wage earner or a minimum wage earner, it can affect benefits paid 2 years from date of injury. And I want to reinforce this. This is benefits paid 2 years after the date of injury, not accruing. So, for example, if you had temporary disability, you had a claim that's denied. 3 years later, it's found to be compensable and TTD is owed. It's subject to the benefit rates at the time that you're paying them. So the current maximum and minimums are applicable. Again, the primary basis is average weekly earnings at time of injury. That employee's average weekly earnings at time of injury. So here's what COLA is doing directly to temporary total disability. Here's our new minimum and maximum average weekly earnings and rates. So our minimum rate for 2022 dates of injury is $230.95. Our maximum is up to $1,539.71. So it's a healthy increase that we have. And here's what our rates have been over the last few years, just to show you how that's been climbing. If there is no increase in state average weekly wage, if there's a decrease, we don't reduce temporary disability benefits. They would just stay the same. We will never decrease rates in California work comp. That's kind of the overriding premise, that we're never going to decrease them. But here's how they've gone up over the years, just to let you know. So COLA with death benefits, they can be affected indirectly based on earnings at time of injury, but 2 years from the date of injury, probably still paying death benefits. You got to look and see what those earnings were, and then see what the current maximum and minimums, and see if an increase is warranted. And I see we've got a question.
Oh, yes, Tim. We had a question from someone in the audience. Does COLA apply to retro TTD as of January 2022?
I'm not sure I understand exactly what the question. To retro TTD, if you have not paid it, the current rates now apply, yes, subject to the average weekly earnings. So it doesn't, you're not increasing it automatically, but if the earnings were $2,100 and you're paying now, where the TTD rate is now up about $1,400, then yes, you're going to pay based on the new maximums.
Yeah,
Still
so for example, if you had a 2020 date of injury, and it's on a denied case, like you said, and tomorrow the case goes to trial, and an FNA comes out from tomorrow's trial saying, up until today, the applicant has been TTD from 2020 through today. Would you apply the max rate from 2021, or the 2020, or the 2022?
You would apply the max rates on the day it's paid, again, subject to the employee's earnings, actual earnings. If the max rate is over their earnings, then you're going 2/3 of the earnings.
Thank you.
I hope that's clear. But that's a tough question. But yes, it's subject to the current rates, still based on earnings at time of injury from that injured worker. So death benefits, you're probably going to be paying those benefits 2 years from the date of injury and beyond. You're paying at least till the youngest minor turns 18, at least till the minimum benefit is paid. So if there's 2 total dependents, you're paying up to $250,000 at the weekly rate until that's paid up. And so anything paid more than 2 years from the date of injury, you might have an increase. If that deceased worker was a maximum or minimum wage earner, you're probably going to have an increase in the rate. COLA does not apply directly to death benefits, and we recently had a panel decision that affirmed that. I'm not going to try to pronounce that. City of Fullerton WCA panel decision, they affirmed COLA does not apply directly to death benefits. It applies indirectly, as I talked about. If you're paying 2 years from date of injury, you got new maximums and minimums to look at, still overriding factors, earnings. But what this decision said was, you know what, this was decided, an en banc decision in 1998. Death benefits are payable as temporary total disability benefits would paid. And Labor Code 4661 says if you're paying them 2 years beyond the date of injury, you're subject to the current ones. And that's the final cap is still earnings on date of injury. So death benefits also, here we go, the two labor codes, 4702B and 4661.5 are the ones that apply in terms of paying it as temporary total disability. And those are the labor codes that were addressed in the initial Phillips versus Smud case in 1998, and the Brzezinski versus City of Fullerton panel case affirmed that that's so. COLA does not apply directly to death benefits, but death benefits can be affected indirectly. So I'm going to give you an example. Let's say it's a 2016 date of injury and death. $2,100 is the average weekly earnings. 2/3 is $1,400. So here's how that would pay. In 2016, the year of that injury, the maximum benefit is $1,128.43. It's going to stay $1,128.43 throughout 2017, and will stay at that until 2 years from the date of injury. So 7/8/18, we look at the current maximum earnings and the current maximum TTD at that time. So it's going to go up. 2019, January 1st, it goes up again. 2020, it goes up again. 2021, it goes up again. 2022, it goes up again. But it's capped at $1,400 based on the earnings of $2,100 a week. So I hope that covers that. John?
Hi, Tim. We have two more questions.
Okay.
The first one is, aren't death benefits reviewed at the 1-year anniversary of death as well for a possible increase?
No.
And second question is, does the increase on death benefits apply if there is an F&A, which includes the rate, but the F&A does not mention the COLA increase?
No. You know that this still rates. If I take it back, an F&A could say anything, but unless it's something unique that's covered and agreed to and contracted in that F&A, no, you're going to increase the benefits 2 years from date of injury based on average weekly earnings at time of injury.
We just got in a few others, and
Okay.
then I'll take a break from asking you questions here. So the next one is, what is the first COLA on the date of injury, and the others are on January 1st?
Are we talking specifically about the death benefit?
You know, yes, they say
Okay,
yes.
so this slide that I'm showing, I'll assume that's what we're asking about. The other one's on the first because we've got new rates. It's already 2 years past the date of injury. So the new rate is in effect the 1st of 2019. So that's when you got to look at it again. And then the 1st of 2020, there's a new rate. We're already 2 years past the date of injury. And 2021, the same thing. We're already 2 years past the date of injury. So this is now the current maximum we have to look at.
Yeah, so basically every January 1st, keep on looking at this 2016 date of injury.
After that first one, the first one is 2 years from the date of injury, and then it's every January 1st, you got to look at it. If you've made an increase. Once you stop making an increase, you don't need to look anymore. So in this particular example, 2023, it's not going to go up. 2024, it's not going to go up. 2025, it's not going to go up. It's going to be set at $1,400 because the earnings were $2,100. 2/3 of that is $1,400.
And last question, and I suspect that the answer is no, Tim, but
Okay.
the question is, does COLA apply to death benefits once a CNR is settled?
COLA does not apply directly to death benefits. If you have a CNR and you're resolving, you're doing a present value, whatever that may be, I'm assuming that's going to be written that that's resolving. You're paying all the money now. There's probably been some calculation of present value, and all this stuff was worked out. And once you do a CNR, you're done. And let me go back. If this person's if the individual's earnings were only $1,200 a week, well, the death benefit is $800. There's not going to be any adjustment. It's going to stay $800 for the duration of that death benefit.
And last one, Tim, I'm sorry, but in regard to what we were talking about earlier, using this 2016 date of injury, would you look at it every January 1st after the 2018 2-year mark, or would you just look at the 2-year mark and never again?
Look at it every January 1st after the 2-year mark until you hit what the maximum could be for that individual's earnings. And in this example, the maximum it can be is $1,400 based on the earnings. So there's no need really to look at it in 2023. It can't go up based on the earnings. So I hope that answers that. Again, feel free to ask me questions later if you want to send me emails. The more specifics you have, the easier it'll be for me to give you an answer on that. So that's death benefits. It can affect indirectly, but COLA does not apply directly. The reason it can affect it is 2 years from date of injury. You're paying as temporary disability, and temporary disability, you got to look at current rates and earnings at time of injury to pay it correctly 2 years from date of injury. With a 104-week cap on TTD, that doesn't come up a whole lot, but if someone's a max earner, it's something we got to pay attention to. Beyond a max earner, something we got to pay attention to. Okay, I'm going to move on to lifetime benefits. So that's anything 70% or more. So life pension and perm total benefits. COLA applies directly to those after they start. Doesn't apply. You're not calculating an increase ahead of time. After that benefit starts, COLA applies directly for dates of injury January 1st, 2003 and later. So there are still cases out there, lifetime benefit cases from prior to 2003. COLA does not apply to those. It does not. They're set at their PTD rate, and that rate continues for the duration of that benefit. 2003, that's when that labor code was passed. Can't really pass retroactive law, so that labor code was passed to give some built-in help for those lifetime benefit cases. That COLA applies every January 1st, 2022 after that benefit starts. So if the benefit starts December 31st, 2021, if life pension starts December 31st, 2021, COLA applies January 1st, 2022. Okay, so it's always January 1st for a lifetime benefit. When you're applying lifetime benefits, and a lot of you are probably administering claims with lifetime benefits. If there has been an attorney and there have been attorney fees paid, they've probably been compensated through a uniform reduction, some sort of a reduction from the fees, future fees, or future benefits for the injured worker. And there's two types of uniform reductions. There's a uniform reduction, I call it a uniform constant reduction, where the reduction stays the same. And then there's a uniform increasing reduction, where that reduction increases. I don't see a whole lot of those anymore, but they were more popular in 2012, 13, 14. So if you have an award you're paying with lifetime benefits, you might want to look at that actual award and see what it says. But let me give you an example of how that could work. COLA affects life pension. Let's say an example of 2007 date of injury, and I'm being non-specific on purpose. An award of October 16th in 2010, 83% permanent partial disability, and it's going to start 7/19/2008. After that 83%, a certain number of weeks associated with 83% Once those number of weeks are done, I calculated out to November 1st, 2020, life pension starts. For 83%, it starts at 177.81. Attorney fees commuted from the side by uniform reduction. What happens then? Well, the DEU in their commutation worksheets tells us, they caution us, always apply COLA to the rate before reduction, then apply the reduction. It says that on all the commutations that they do for lifetime benefit cases. And they typically, if the DEU is involved, they're asked to do a commutation, you'll get the actual reduction. So this example is from a commutation by uniform reduction. The DEU typically does two methods, the uniform constant reduction. So here's the initial rate, 177.81. 39.14 will be the uniform reduction. So the benefit to the injured worker is 138.67 starting in 2020. Method 2, which they always give, usually you get to choose somebody, unless somebody has decided that's what they want one way or the other. But the method 2 is uniform increasing reduction, in which case the reduction starts much lower and increases. In this example, and what the DEU is doing now, the increase is also a 3% increase. So it's a fixed increase of 3% every year on that commutation. So you want to check your award and see what you've got. If you're going to be applying COLA to a lifetime benefit, you want to look at that and see what you've got. So I'm going to go through the examples of how you do that, how you apply that COLA. So that example I gave, the 177.81 minus 39.14, so 138.67 to the injured worker. COLA applies January 1st of 2021. You apply that COLA to the 177.81 and then subtract the 39.14. For 2022, you apply the COLA to that new rate before reduction, and then you subtract the constant reduction. So that's how you apply that. As we talked about earlier, we've got a blog article that goes through an example a little bit more thoroughly on our website if you want to look at that or give me a call. So that's how that works out. For the uniform increasing reduction, in this case, the DEU actually gives you what those reductions will be, and they have the increase based on 3%. That's what they're doing. This is how that's going to work. So the rate before reduction, COLA still applies to that. The reduction increases and you subtract. So that's a chart that shows you how that's going to work, how you're going to apply COLA to those benefits. So here's what I got, what we covered: state average weekly wage, cost of living adjustments. There's a direct effect on TTD rates. The overriding factor is still earnings on date of injury. Maximum and minimums change based on COLA, or don't change. We've had a couple of years where it hasn't changed because there has not been an increase. There's an indirect effect because of the 2-year rule and the labor code regarding death benefits that's to be paid as TTD. It could indirectly affect death benefits paid 2 years or more past the date of injury, still subject to earnings on date of injury. Direct effect on lifetime benefit cases. Be cautious about how you're applying that. You apply it on the rate before reduction and then take the reduction. Okay? And this is how you contact me. Again, I'll be glad to answer questions. But that's COLA, state average weekly wage, cost of living adjustments, and the effect it can have on benefits. So thank you very much.
Thank you, Tim. Okay, we have Zane coming on next, and I think we're going to start with a couple of poll questions here, Zane, aren't we?
I think so. Sure, let's go ahead.
Thanks again, Tim. Thank you all for the wonderful questions for Tim, too. If you have any more, don't forget to email him. Okay, poll question number 1 from Zane. Have you had to do a home COVID test on a child? I can
And
tell
let me
you
tell you,
yes
not,
for me, Zane.
yeah,
I don't know
not one
about
of your
you.
fun activities. Definitely not something you want to have
No,
to do more than once.
exactly. Okay. Almost all of them have voted. We're pretty close here. And actually, it's quite surprising. I'm going to share the results here, but it looks like 81% said no, they haven't had to.
Wow.
I
The
think we've
lucky
done,
ones.
I think we've done like 9 of them at our house. Okay, second question. Is there anything worse than having to do a nose swab on a child for a home COVID test? So for those of you who answered yes, my children are teenagers, so I didn't have to do it for them. They were able to do it themselves. How about you, Zane?
My son is 5, and despite the fact that he will frequently put his finger up his nose, he will not let you put a Q-tip anywhere near his nose. So I did have to wait until he was actually asleep to try to do it, and then still do it quickly, because that's going to wake up a sleeping dragon.
All right, well, about 55% said no. So, all right, Zane, thank you.
Sure, okay. And now we're going to get to the part of the presentation where we go ahead and add that shot of COVID to cola here and kind of talk a little bit about what's been going on in terms of how cases have been going and being handled at the Workers' Compensation Appeals Board, and what are we seeing, and what are kind of the trends? Also, what are the questions? What are the areas where there's a lot of questions that arise because of either something being very complicated, something being either confusing, or because of all the different factual scenarios that can arise when you look at COVID claims themselves. So we do have that email, covid@bradfordbarthel.com, for questions. Please do submit your questions here. John will interrupt me with questions. We love to get those. But if we don't get to a question, please do feel free to email us with that question afterward. So what are the kind of topics that we've been seeing with a lot of questions on? I briefly do want to touch on sick pay, since it did expire. The statutory sick pay that individuals were receiving, that COVID pay, did expire. Replacements are being considered. That is going through the legislative process. One of the reasons it probably wasn't immediately put back into place is that there was a federal tax offset to help employers pay for that sick pay that they were getting a tax break on it, and that tax break also expired at the same time. So that's probably holding that up a little bit. But the most frequent issue that we see, though, is if a claim is accepted and TTD is owed, there is no waiting period. Go ahead and get that TTD going. Without that sick pay to exhaust first, TTD benefits are going to be due right away. Another big issue is testing. Not only whether or not someone has a test, but also what kind of test is an acceptable test. And we've had questions on testing and issues that I've seen on litigated and non-litigated cases, because we've got so many that have come through in about the last 22 months at this point. And we have seen literally everything. I have seen individuals submit a test that wasn't their test. I have seen a test submitted for one of the older versions of SARS that's not COVID. So we've seen that. So we've kind of seen so many different things come up. And there are now at this point a lot of different tests. So the question comes up, what is a valid test, and what would actually constitute a valid test? John, we're on our first question now. Go ahead.
Hey, Zane, this is actually a question which you and I had kind of anticipated. It's similar to what we were talking about. And the question is, a public entity can do their own PCR test, and they send these PCR tests that they're doing out to a lab. The results are returned via an app. Is this sufficient for a claim to be compensable, or do we still need a valid diagnosis by a physician?
At this point, we would need the valid test. So the diagnosis was under the prior presumption that was what we refer to as the executive order presumption. So there could have been a diagnosis followed up with testing, but at this point, when we look at the presumption that includes the outbreak, you just have to have a positive test. You don't have to have a doctor's note. You don't have to have a doctor's diagnosis. You're going to need those things if there's going to be any medical treatment or if there's going to be any TTD that's paid. But frequently we do see individuals submit a positive test. There is an outbreak and it qualifies for the presumption, and nothing happens after that. They never receive medical treatment. They return back to work. While they may have a compensable claim, there's not much that's going to come out of that claim, usually PD denial notice, and then the file will close. But when we are looking at those tests, yes, a PCR test is an acceptable test, and it is actually the gold standard. It's written right here into the code section here that defines what a test is. And it's important here at this point to note that in the presumption statute, they very specifically listed what they felt would be a valid positive test. It has to be a PCR test that has been approved by the FDA to look for the presence of viral RNA. They specifically exclude the antibody test as a valid form of testing. Yes, we have seen those. I have seen cases where they attempt to show an antibody test even months later to show that an individual had COVID at some point, and then try to use that to qualify under the presumption. And of course, those claims would be denied. That test is specifically excluded here from the definition of testing. But the definition then goes on to say a test may include any other viral cultural test that's been approved by the FDA to detect the presence of viral RNA, which has the same or higher sensitivity. And that's where we kind of start parsing at the language here. We're looking for other viral culture tests to detect the viral RNA with the same or higher sensitivity. And of course, the great question comes up is, how do we know if that's what a test is doing? If it's a PCR test, an NAA test, which is a nucleic acid test, or an antigen test. And the easiest way to know what these things are, what the test actually does, and specifically what the sensitivity of a test is to look at the documentation that the manufacturer actually submits to the FDA when they're trying to get approval. Much of this documentation is available online. I can find it usually on the CDC website itself for any particular test. And they will go through what the sensitivity of the test is, sort of the accuracy of the test, and also what kind of test it is. What exactly is it looking for? Is it looking for the virus itself? Is it looking for a byproduct of the virus, like an antigen? Is it looking for antibodies? So then it will have that, and then it will have that sensitivity that is listed out. But in order for the test here, as we see in the definition, to qualify as a valid test, the test is going to have the same or higher sensitivity as the PCR test. So this is the statute, this is the way the statute has been written, and this is the language that governs the presumption. There's nothing to say that this might not change through either new legislation later or through court decisions later on saying what is and what is not a valid test. Oftentimes the courts have very interesting ways of interpreting things. But if we're just going off of what the language in the statute is and trying to determine if we have a valid test that's going to qualify someone to have the presumption apply that their COVID is work-related, we're going to have to go ahead and just follow what the statute itself is actually saying. Another thing to note is there was an NIH study that found that sort of the accuracy that's being reported by the test manufacturers is sometimes much lower and can definitely be off. So, and sometimes this has to do with testing conditions, how the test is done, especially with the home tests. You'll find those off more often because it's not doctors or medical professionals doing it. It's me trying to swab my child's nose and then trying to utilize a solution and get the right number of drops in the right part of the container without contaminating anything. So, and you know, lawyers, we're not doctors, we just play them during cross examinations. So the sensitivity of the test is overall what we're looking for, and that's what we have to look at when we decide, is the antigen test going to be a valid test as compared to a PCR test? One of the first things we want to look at is sensitivity. John, you got a question?
Yeah, Zane. So we did have a client or someone ask, we are now seeing clinics doing PCR rapid test, which I have not seen. I've seen clinics doing antigen test or PCR test. So this person's saying it's a rapid test being done at a clinic, but it is not PCR as it is not sent to a lab. Is that acceptable as PCR? And I believe that the answer would be no, right?
It would depend on what exactly that PCR test is doing and what it's looking for. But if it's going to be one of those rapid tests that's not actually looking for the viral RNA and it's kind of hiding as a PCR test, then it's not going to be valid. But again, this is something where we would want to go and look at exactly what is it doing. Is it actually looking for the virus? Are they just doing the reaction? Are they doing the reaction in a quicker way? Do have to watch out for those advertisements, because I recently discovered that what places will do, testing sites will do, is they will do a PCR test and an antigen test at the same time, and they'll tell you you can get your results in 15 minutes, but that's not what they're advertising. You get your PCR results, 1 or 2 days later. So you do need to be careful about that. But in terms of what would a PCR test, a rapid PCR test, be valid? And that gets back to how sensitive is the test. The current PCR tests have a sensitivity of 98%. They're almost always detecting COVID. They're not giving a lot of false negatives, and they're not missing the positives that they should be, that they shouldn't be missing. The antigen tests, while we go back to about March of 2020, some of them only had 50% sensitivity. They were not very good. They've slowly become better, hitting the 80s, and some of them are in now the low 90% in terms of sensitivity for that test. Hey, John, another question?
We are getting, so there's too many questions for me to ask right now, but a lot of them do touch on on something which we've addressed in our supplemental paid sick leave blog, which came out in October. And that is that if you have a work-related exposure to COVID-19, the Cal OSHA rules and regs say that you have to say that the employer has to essentially pay the employee as if they're still there, and it does not have an 80-hour limitation on that. But what's interesting is that, and I've seen people get confused over this recently, and I'm sure you have too, Zane, is that doesn't take away the carrier's right or the TPA's right to decide whether to accept or deny the claim, as they're still doing their investigation during that time. So I guess where I'm going with this is a lot of these questions focus in on what do you do on day 13 if there's been a claim that's reported, it's a work-related exposure. Should the employer pick up benefits, and if the carrier owes TPA, if the carrier owes TTD, should they pick up temporary disability later on or at the end of the 14-day period?
Yeah, and you may find that after your investigation, where you thought you were not going to have a presumption apply, you do end up having that presumption apply, and then in that case, you may even owe retro TTD back to the date where it should have been paid, where maybe the wage continuation ended or other sick leave had in fact ended. But yes, the rules are a bit of a mishmash when it comes to what am I supposed to be paid and how long, because when you do dig down into those Cal OSHA regulations, they do talk about maintaining earnings, and what exactly does that mean, and maintaining the person's position so that it's available for them. But they may be out longer, than simply 2 weeks or 80 hours. So you have to look at that on a case-by-case basis, but definitely when you end up in a situation where the claim is accepted, you want to go ahead and get those temporary disability benefits picked up.
And then just one other thing I wanted to note real quick on that same topic. If it's a non-work related exposure to COVID, but the employee is still out, there's 5 jurisdictions that we're aware of right now, cities and counties, that still have their own, hey, you have to pay up to 80 hours rule. Those are the city of LA, the unincorporated county of Los Angeles, the city of Oakland, the city of Long Beach, and San Mateo County. So if your employer is in any of those places and they don't know if it's a work-related exposure or not, they still have to pick up COVID pay while that employee's out, because that's what the local government says.
Yes, and that's a good point. It is important to check on those county rules, because we are seeing different rules, especially in the larger counties, in terms of just everyday activities such as wearing masks. You may have to do that in one county but not another county, but then also the rules regarding pay may be different as well. To kind of break down the differences here though between the tests, the antigen test is looking for proteins, antigens that are given off by the virus. It's not actually looking for the RNA of the virus. And the CDC website itself indicates that if you do test positive with an antigen test, they recommend that you get a confirming test with a PCR test after the fact to make sure that your initial test was correct. because even the CDC website acknowledges that that test is less sensitive. So if it does not detect the viral RNA, which is required by our definition statute, and it's not as sensitive as a PCR test, it makes it very difficult to say that an antigen test should just, as a blanket rule, be accepted as a valid test for COVID-19. It's not hitting those particular statutory requirements. Now, one day it may. The sensitivity, as I was saying, about the antigen test has been improving over time, and it's getting closer and closer to what is that 98% for the PCR tests. But if it is not as accurate, especially if it's one of those tests that can be fooled by other conditions and return a positive even when an individual doesn't have COVID, that's not going to be the kind of test here that the statute imagines us using, and that we would then want to use, in an accepted claim. So that's a question. We do get a lot of questions on testing, and if you have other questions, please email them, because I know we're going through this briefly. I also want to talk about a specific place of employment, because I get that question a lot too. What constitutes a place of employment? Because the statute, as you can see here, defines it as a building, a store, a facility, or an agricultural field. The statute also contemplates individuals having multiple places of employment. So if you think about a donut shop that has multiple locations in multiple places, that one person works at one retail location and then goes to another retail location, they fairly clearly have two different places of employment. They have one place separated, of course, geographically, and those are considered two different places of employment. The difficulty comes down to, what do you do when you have a building that has 6 floors worth of people on it? Do you consider each floor to be its own place of employment? What if you have a facility that has 9 buildings on it? What are you looking at there? Are you considering the entire facility to be a place of employment? And one particular tip there is, do the employees interact? The more the employees interact on multiple floors or in multiple buildings, the harder factually it's going to be to say that those are separate places of employment. If everyone is able to move back and forth and it's considered one large workplace, then that's likely going to be considered one particular location. If you have 2 facilities that are on the same plot of land, as I have seen, but are owned by 2 different companies, 2 different corporations. Corporations do have a common owner, but 2 different corporations, and they have different employees and they produce different products, it's much more likely that each facility, each building in that case, would be considered its separate place of employment. Do remember that when you are calculating an outbreak and you're looking at a place of employment, the more employees that are at a place of employment means it will be harder to reach that outbreak threshold when trying to do that calculation, because you have to have 4% of the individuals working at the location test positive for there to be an outbreak. So if you break a place of employment down too much to its smaller and smaller sections, you're more likely to end up with an outbreak by artificially saying that this is, one part of a building is a separate place of employment compared to another part of the building. Or in the case of, say, a law firm like where I work, saying that the attorneys are one place of employment, but the support staff is a separate sort of entity. Breaking it down like that will also make it more likely that you will end up with more outbreaks, but it also won't be factually able to be supported, given the fact that if individuals are crossing over and moving into each other's workspaces, it's more likely to be considered one single place of employment. Also, I do want to touch on the decision time frame, because I get asked if an individual is not utilizing one of the presumptions that is available, what is the decision time frame? Do they have 30 days, 45 days, or is it 90 days for a regular claim? And while it's arguably 90 days for that decision to be made, it's difficult to imagine a scenario where an individual comes to its employer and hands him the claim form and says, I'm making a claim for COVID exposure, but I'm going to go outside the presumption and utilize subsection E's exception and prove my case by a preponderance of the evidence. It's never going to be that clear. And since it's not going to be that clear and you're just going to get a claim form, you're going to evaluate the claim based upon either the 30 or 45 days, depending on if they're a first responder or if they're in the outbreak presumption. And since you have to make a compensability decision on the presumption in that shortened time, we recommend that you make the compensability decision for a claim outside the presumption at the same time. So if you just do decide to deny a case because their individual, say, doesn't have a positive test, or because there was no outbreak, you can also list in that denial, we're also denying the claim based upon our employer level investigation that does not reveal any industrial injury or any source of exposure. And you can put that in as well, but you do want to think about that. Don't think about them as separate claims. I know that we will do that and judges will do that when it comes down to taking the matter forward to trial. But the injured worker handing you a claim form is not thinking, I'm going to take this with the presumption, or I'm going to take this outside of the presumption. So I would just recommend you make the decision within the applicable time frame for the presumption. John?
Zane, yeah, so in short, we did have a good question about the decision time frame. And so this person had asked, what if the employer is giving the DWC-1 to the applicant for them to turn in, but eventually the DWC-1 lands on the claims adjuster's desk with only the employer portion of that form completed. So she asked, doesn't the employee still have to sign that DWC-1 form and return it to start that 45-day decision time frame under the outbreak, or 30-day under the first responder?
And I would think that the answer there would have to be yes. The employee is going to have to fill out some portion of it and actually return the claim form. If the claim form is only filled out by the employer, and what we go back to is, of course, we go back to the Honeywell case and what actually triggers the time frame to begin running, and that's when that claim is actually made. So when that claim form is actually returned, that's when this is being started. And if that never happens, if we only have the employer filling it out, it'd be hard to say that the time has actually begun to run in that particular case, and that you are now on the clock. This has been strange, and understandably so, for these particular cases, because it's not usually a secret when someone has COVID in the workplace. It's usually well known. The employer is made aware of it. And there's Cal OSHA regulations saying how much they have to document and keep track of it. But the claim itself actually comes later, sometimes months and months later, before a claim itself is actually going to be made. So we do have to keep in mind that the triggering event for that decision time frame is the returning of the claim form.
And Zane, someone asked an excellent question. For employers, and they're using public schools as an example, but it could be anyone, for any employer who tests frequently using the antigen test, is that valid for making a workers' compensation claim?
And that is one thing that is not directly addressed by the statute, but when you begin to think about how workers' compensation works, that could end up being an exception to whether or not an antigen test could be used. And here's sort of the scenario, the way you just laid it out. If the employer provides you with the antigen test, so if the employer is giving the antigen test to its employees and saying, please use this, let us know if it's positive. And if the employees do that, and then it comes back positive, and then the employer says, okay, well, you need to stay out for a certain number of days. You have COVID. They're out, they come back, they file a claim, and then the employer says, well, you didn't use a valid test. That's going to be very hard, I think, for a judge to accept because of the employer's sort of action and interference in that case. They handed an employee a test and said, use this test, and then tried to claim later on, this is not a valid test. So while the statute itself doesn't speak to it, it would seem to be a very tough position to defend if the employer is actually giving out a particular test and saying, we're going to accept this as a positive test if it comes back that way, and we will, proceed accordingly. So that could definitely be an exception. It would not surprise me if that ends up as a judicial exception that comes through the courts as to whether or not that kind of test would be accepted, or even if a diagnosis might be accepted if there was something that the employer voluntarily took as a positive test. Briefly, as we are running out of time, I do want to touch on this because we have cases that have the presumption that may apply, and we also have cases where people try to go outside the presumption and they say, I'm going to prove that I got sick because Bob at work was sick first, even though I don't have maybe a positive test or I don't meet the outbreak requirement. And the question always comes up, can't I just set the matter for AOE/COE trial and push the case forward? Why do we have to do further discovery? And the panel decision that we have here, the WCAB ultimately said, determining whether or not an outbreak has happened and doing that discovery can be a bit complicated, and they were willing to give the applicant more time rather than just the amount of time to say, do you have a test? Was there an outbreak? And then sort of ending the inquiry at that point. And this kind of mirrors also what we have seen when we've gone down to the board. I've filed DORs for priority conferences, gone down and had cases set for trial, and I had one set for trial on whether the presumption applied. And the trial judge looked at it and said, if I rule in your favor that the presumption doesn't apply, and after looking at it, he said it's very likely that's not going to apply, then the applicant's going to go get a panel evaluation to try to say that he was ill. He's going to go gather witness statements saying that he was around other people at work that were ill, and then try to show outside the presumption that he has a valid claim. Then that would have to be set for AOE/COE trial again. And the judge said, I don't want to try the same thing twice. I want to do one priority trial. I want to do one determination on whether or not this injury is compensable, no matter what legal theory is being used. So normally in these kind of cases where it looks like the presumption doesn't apply, we should just go straight to trial. It is very likely that there's going to be some allowance for additional discovery to try to prove a case outside of the presumption. I know that we are running low on time. I wanted to mention the outbreaks, but that was kind of in connection with what constitutes a place of employment. If you have a facility that has 1,000 people working there, but if you break down that facility down into all of its smaller buildings or smaller departments, and every department only has 12 or 15 people in it, each time you have 4 tests positive, you're going to have an outbreak. And that's probably not a fair breakdown of what constitutes a place of employment, but it will end up having you have more outbreaks because you're going to end up with smaller areas that have less than 100 employees, so you only have to have 4 positive tests, rather than locations that would have more than 100 employees where you have to have 4% of the individuals test positive. And it's just more true to the actual fact when you're looking at a place of employment. Is the entire place considered, this is one place that the employer operates? It's much more true to sort of the facts on the ground if you consider that to be one place of employment. Vaccinations are a constant question that we get. The real shorthand is if the employer wants you to get the vaccination and there is an injury, that is going to be an injury that is going to be compensable. Or if the employer encourages it, if the employer gives you an extra vacation day if you do get vaccinated, or pays you a certain amount of money to get vaccinated, that will also be a compensable claim. But what about the mandates for vaccinations? If there is a mandate that comes down and then says everyone has to get vaccinated, as we recently saw. There were 2 mandates that were issued by the federal government. The Department of Labor issued one that applied to about 84 million workers, and then there was the Health and Human Services Department that issued another one that just applied in Medicare type cases that applied to about 10 million healthcare workers. The healthcare one was upheld. The other one has been stayed by the Supreme Court, and at some point during this presentation, actually, the president actually removed that particular requirement, and that has now been rescinded. So there shouldn't be any further court action on that requirement that everyone with over a company of a certain size be vaccinated. That requirement has now been rescinded within the last hour or so. John?
We actually did have a news break during the presentation. Thank you, Dan Stovall, for pointing that out. Within the last hour, there was an announcement from Governor Newsom that there's a new deal to reinstate COVID-19 sick pay. So while that's not going to make some people happy, it does simplify the work comp aspect of what happens during the initial 14 days after a positive test.
It does, and then we don't have to kind of get into what was going to end up being a litigated issue on whether or not those Cal OSHA requirements that are health requirements actually required pay to continue to be made to the employees. So if it's going to be reinstated at the 80 hours of sick pay, that does simplify things. But the fact that we had the governor make a change to something that we were talking about today, and the president make a change to something we were also talking about today, shows that this is very fluid. and that there are frequent changes and new questions arise. So that's why we do encourage you, contact us with questions. We do have that special email, covid@bradfordbarthel.com. You can email us questions on all of these different topics. We are happy to answer them and happy to help.
And I did just want to state that is just a proposal, by the way. That isn't the law yet, but it probably will be in the next month or so. Just didn't want to confuse anybody.
Thank you so much, Zane. Thank you, Tim. And John, thank you so much for answering so many questions. Your fingers must be hurting from typing and then bringing a bunch of them online. We appreciate it. We appreciate all of your questions. It makes the webinar more interesting and more interactive. So thank you all for that. I have a couple of very quick things and then I promise we will let you go. I know you're all very busy. Like Zane said, if you have more questions, please email our covid@bradfordbarthel.com. We have a team of experts ready to answer those COVID questions. And with that, I think that's all we have for today. You guys, anything else? Okay.
Thank you, everybody.
Thank you for joining us. Have a great rest of your week. Take care.